first case I'm reading about self-dealing transactions is from the Supreme Court of Iowa, 1988, on Cookies Food Products versus Lakes Warehouse. Justice Newman gives the opinion on page 683 of corporate law text. This is a shareholders derivative suit brought by the minority shareholders of a closely held Iowa corporation specializing in barbecue sauce. Cookies Food Products, Cookies, Inc., Cookies. The target of the lawsuit is the majority shareholder, Dwayne Speed Herring, and his two family-owned corporations, Lakes Warehouse Distributing, Inc., and Speeds Automotive, Inc., Speeds. Those are the target of the lawsuit. Plaintiffs allege that Herring, so they're the defendants, Herring, by acquiring control of Cookies and executing self-dealing contracts, breached his fiduciary duty to the company and fraudulently misappropriated and converted corporate funds. Plaintiffs sought actual and punitive damages. Trial to the court resulted in a verdict for the defendants, the district court finding that Herring's actions benefited rather than harmed Cookies. We affirm. Background. L.D. Cook of Storm Lake, Iowa, founded Cookies in 1975 to produce and distribute his original barbecue sauce. Searching for a plant site in the community that would provide financial backing, Cook met with business leaders in 17 Iowa communities, outlining his plans to build a growth-oriented company. He selected Wall Lake, Iowa, persuading 35 members of the community, including Herring and the plaintiffs, to purchase Cookies stock. All of the investors hoped Cookies would improve the local job market and tax base. The record reveals that it has done just that. Early sales of the product, however, were dismal. After the first year's operation, Cookies was in dire financial straits. Cookies' board of directors approaching Herrig with the idea of distributing the company's products. It authorized Herrig to purchase Cookies sauce for 20% under wholesale price, which he could then resell at full wholesale price. Under this arrangement, Herrig began to market and distribute sauce to his auto parts customers to grocery outlets from Lake's trucks as they traverse the regular delivery routes for Speed's Automotive. In May of 1977, Cookies formalized this arrangement by executing an exclusive distribution agreement with Lakes. So, Herrig was a promoter, or maybe not a promoter, but we'll call it that for now. Herrig was first a promoter, and was he a shareholder? Then he got this marketing agreement, exclusive distribution agreement. Cookie sales have soared under the exclusive distributorship contract with Lakes. As sales increased, Cookies' board of directors amended and extended the original distributorship agreement. In 1979, the board amended the original agreement to give Lakes an additional 2% of gross sales to cover freight costs for the ever-expanding market for Cookies sauce. In 1981, L.D. Cook, the majority shareholder, up to this time decided to sell his interest in Cookies. He first offered the directors an opportunity to buy his stock, but the board declined to purchase any of his 8,100 shares. Herring then offered, and all the shareholders Herring then offered Cook and all the other shareholders $10 per share for their stock, which was twice the original price. So then Herrick became most likely a director. Because of the overwhelming response of these offers, Herrick had purchased enough cookie stock by January 1982 to become a majority shareholder in that. Actually, he wasn't a director yet. I take that back. Majority shareholder. Shortly after Herrick acquired majority control, he replaced 4 of the 5 members of the Cookies board with members he selected. This restructuring of authority allowed, following on the heels of an unsuccessful attempt by certain stockholders to prevent Herrick from acquiring majority status, solidified a division of opinion within the shareholder ranks. Subsequent changes made in the corporation under Herrick's leadership formed the basis for this lawsuit. First, under Herrick's leadership, Cookies board has extended the term of the exclusive distributorship agreement with Lakes and expanded the scope of services for which it compensates Herrick and his companies. In April 1982, when the sales increase of 25% over the previous year required Cookies to seek additional short-term storage for the peak summer season, the board accepted Herrick's proposal to compensate Lakes at the going rate for use of its nearby storage facilities. The board decided to use Lake's storage facilities because building and staffing in its own facilities would have been more expensive. Later in 1982, the new board approved an extension of exclusive distributorship agreement. Notably, this agreement was identical to the 1980 extension that the former board had approved, while the 4 of the plaintiffs in this action were directors. Herrick moved from his role as director and distributor to take on an additional role in product development. So he was a director and distributor, now product development. This created a dispute over the royalty that Herrick began to receive. Herrick's role in product development began in 1982 when Cookies diversified his product line to include taco sauce. Herrick developed the recipe because he recognized that taco sauce, while requiring many of the same ingredients needed in barbecue sauce, is less expensive to produce. Further, since consumer demand for taco sauce is more consistent throughout the year than the demand for barbecue sauce, this product line proved to be a profitable method for increasing year-round utilization of product facilities and staff. In August of 1982, Cookies board approved a royalty fee to be paid to Herrick for the taco sauce recipe. The royalty plan was similar to royalties the board paid to L.D. Cook for the barbecue sauce recipe. That plan gives Cook 3% of gross sales of barbecue sauce. Herrick receives a flat rate per case. Although Herrick's rate is equivalent to the sales percentage slightly higher than what Cook receives, it yields greater profit to Cookies because this product line is cheaper to produce. Third, since 1982, Cookies board has twice approved additional compensation for Herrick. In January of 1983, the board authorized payment of a $1,000 per month consultant fee in lieu of a salary because accelerated sales required Herrick to spend extra time managing the company. Averaging 80-hour work weeks, Herrick devoted approximately 15% of his time to Cookies and 80% to Lake's business. In August of 1983, the board authorized another increase in Herrick's compensation. Further, at the suggestion of the Cookies director, who also served as an accountant for Cookies, Lakes, and Speeds. The Cookies board amended the exclusive distributorship agreement to allow Lakes an additional 2% of gross sales as a promotion allowance to expand the market for Cookies products outside of Iowa. As a direct result of this action, by 1986, Cookies regularly shipped products to several states throughout the country. As we have previously noted, however, Cookies' growth and success has not pleased all its shareholders. The discontent is motivated by two factors that have effectively precluded shareholders from sharing in Cookies' financial success: the fact that Cookies is a closely held corporation, and the fact that it has not paid dividends. Because Cookies stock is not publicly traded, the shareholders have no ready access to buyers. For their stock at current values that reflect the company's success. Without dividends, the shareholders have no ready method of realizing return on their investment in the company. This is not to say that Cookies has improperly refused to pay dividends. The evidence reveals that Cookies would have violated the terms of its loan with the Small Business Administration if it had declared dividends before repaying that debt. The SBA loan was not repaid until a month before the plaintiffs filed this action. Unsatisfied with the status quo, a group of minority shareholders commenced equitable action in 1985. Based on the facts we have detailed, the plaintiffs claim that the sums paid Herrig and his companies grossly exceeded the value of the services rendered, thereby substantially reducing corporate profits and shareholder equity. Through the exclusive distributorship agreements, taco sauce royalty, warehousing fees, and consultant fee, plaintiffs claim that Herring breaches fiduciary duties to the corporation and its shareholders because he allegedly negotiated for these arrangements without fully disclosing the benefits he would gain. The plaintiffs sought recovery for lost amounts and accounting to determine that the full extent of the damage. Lost profit. Okay. Attorney's fees, punitive damages, appointment of a receiver to manage the company properly, removal of Herrig from control, and sale of the company in order to generate an appropriate return on their investment. Having heard the evidence presented on these claims at trial, the district court filed a lengthy ruling that reflected careful attention to the testimony of the 22 witnesses and myriad of exhibits admitted. The court found that 1, the exclusive directorship arrangement has been the key to corporate growth and expansion, and the fees under the agreement were appropriate for the diverse services Lakes provided. 2, the warehousing agreement was fair because it allowed Cookies to store its goods at the going rate, and the board had considered and rejected the idea of constructing its own warehouse for storage at the Lakes facility, which would be less expensive. And 3, the taco sauce royalty agreement appropriately compensated Herrig for the value of his recipe. And 4, the consultant fee is actually a management fee for services rendered 7 days a week and is well within reason considering the success of the business. Additionally, the district court found that Herrig had withheld no information from directors or other shareholders that he was obligated to provide. The court concluded its findings with the following observation. The court believes that the plaintiff's complaint is not that they have been damaged, but that they have not been paid a profit for their investment yet. There is a vast difference. Plaintiffs have made a profit. That profit is in the form of increased value of their stocks rather than in the form of dividends because of the capital considerations of operating the company. On appeal from this ruling, the plaintiffs challenge 1, the district court's allocation of the burden of proof with regard to the 4 claims of self-dealing, the standard employed by the court. So there's like 5 issues. to determine whether Herrig's self-dealing was fair and reasonable to Cookies. 3, the finding that any self-dealing by Herrig was done in good faith and with honesty and fairness. And 4, the finding that Herrig breached no duty to disclose crucial facts to Cookies board before it completed deliberations on Herrig's self-dealing transactions. And 5, the district court's denial of restitution and other equitable remedies as compensation for Herrig's alleged breach of his fiduciary duty. Duty of loyalty. So part 2 is fiduciary duties. Herrig, as an officer and director of Cookies, owes a fiduciary duty to the company and shareholders. Herrig concedes that Iowa law imposed the same fiduciary responsibilities based on his status as majority stockholder. See Des Moines Bank and Trust versus George M. Betchel and Company, Iowa, 1952, hereinafter Betchel. Appellants claim that Herrig violated his duty of loyalty to Cookies. That duty derives from the prohibition against self-dealing that inheres in a fiduciary relationship. From Norland, as a fiduciary, one may not secure for oneself a business opportunity that in fairness belongs to the corporation. From Rowan versus Lamar's Mutual Insurance of Iowa, as we noted in Betchel, corporate directors and officers may, under proper circumstances, transact business with the corporation, including the purchase and sale of property, but it must be done in the strictest good faith with full disclosure of the facts too, and consent of all concerned. So these are your elements. And the burden is upon them to establish their good faith, honesty, and fairness. Such transactions are scanned by the courts with skepticism and the closest scrutiny and may be nullified on slight grounds. It is the policy of the courts to put fiduciaries beyond the reach of temptation and the enticement of illicit profit. Against this common law backdrop, the legislature enacted Section 496A34, quoted here in pertinent part, that establishes 3 sets of circumstances under which a director may engage in self-dealing without clearly violating the duty of loyalty. This is the rule. No contract or other transaction between a corporation and one or more of its directors or other corporation, firm, association, or entity in which one or more of its directors or officers are financially interested shall be either void or voidable because of such relationship or interest if any of the following occur. 1, 2, and 3. 1, the fact of such relationship or interest is disclosed or known to the board of directors or committee which authorizes, approves, or ratifies the contract or transaction without counting the votes of such interested director. The fact that such relationship or interest is disclosed or known to the shareholders entitled to vote on transaction, or they authorize such contract or transaction by vote or written consent. And 3rd, the contract or transaction is fair and reasonable to the corporation. Some commenters have supported the view that satisfaction of any one of the foregoing statutory alternatives in and of itself would prove that a director has fully met the duty of loyalty, and that is proposed in Hansel, Austin, Wilcox, Director Liability under Iowa law, duties and protections. We are obliged, however, to interpret statutes in conformity with the common law wherever statutory language does not directly negate it. Because of common law in this section, require directors to show good faith, honesty, and fairness. But they look at it in common law. That's Bobby. Common law and I guess precedent. So it's looking for this. Good faith, honesty, and fairness. In self-dealing, we are persuaded that satisfaction of any one of these 3 alternatives under the statute would merely preclude us from rendering the transaction void or voidable outright solely on the basis of such a director's relationship or interest. Okay, so To the contrary, we are convinced that the legislator did not intend by this statute to enable a court in the director's shareholders derivative suit to rubber stamp any transaction to which a board of directors or shareholders of a corporation have consented. Such an interpretation would invite those who stand to gain from such transactions to engage in improprieties to obtain consent. We thus require directors who engage in self-dealing to establish the additional element that they have acted in good faith, honesty, and fairness. Holy Rest Inc. vs. Trey Loire of 1974 in Iowa. The burden of proof, the court held that the district court had appropriately placed the burden of proof on Herring. Standard of law. Next, appellants claim the district court applied an inappropriate standard of law to determine if Herrick's conduct was fair and reasonable to cookies. Appellants correctly assert that self-dealing transactions must have the earmarks of arm's-length transactions before a court can find them to be fair and reasonable. And the crux of the appellant's claim is that the court should have focused on the fair market value of Herrick's services to cookies rather than success cookies achieved as a result of Herrick's actions. We agree with the appellant's contention that the corporate profitability should not be the sole criteria for which the test of fairness and reasonableness to Herrick's fees. In this connection, appellants cite authority from Michigan Supreme Court that we find persuasive. Given the instance of an alleged director enrichment at corporate expense, the burden to establish fairness resting on the director requires not only sharing a fair price, but also showing a fairness of the bargain to the interest of the corporation. Phil Buildings, Inc. versus Alexander Hamilton Life Insurance Company of 1976 is the site for that quote. Applying such reasoning to the record before us, however, we cannot agree with appellate's assertion that Herrick's services were either unfairly priced or inconsistent with Cookie's corporate interests. There can be no serious dispute that the four agreements and issue for exclusive distributorship, taco sauce royalty, warehousing, and consulting fees have all benefited Cookies as demonstrated by its financial success. Even if we assume Cookies have procured similar services from other vendors at lower costs, we are not convinced that Herrick's fees were therefore unreasonable or exorbitant. Like the district court, we are not persuaded by appellant's expert testimony that Cookies sales and profits would have been the same under agreements with other vendors. As Cookies board noted prior to Herrick's takeover, he was the driving force of the corporation's success. Even plaintiff's expert acknowledged that Herrick has done the work of at least 5 people: product supervisor, advertising specialist, warehouseman, broker, and salesman. The expert conceded that Herrick may in fact be underpaid for all he has accomplished. We believe the board properly considered the source of Cookie's success when it entered these transactions, as did the district court when it reviewed them. Denial of equitable relief is the 5th question. The record before us aptly demonstrates that all members of Cookie's board were well aware of Herrick's dual ownership in Lakes and Speeds. We are unaware of any authority supporting plaintiff's contention that Herrick was obligated to disclose to Cookie's board or shareholders the extent of his profits resulting from these distributions and warehousing agreements. Nevertheless, the exclusive distribution agreement with Lakes authorized, so he had no obligation. Appellants cannot Nevertheless, the exclusive distribution agreement with Lakes authorized the board to ascertain that information as it so desired under law, but I guess they have it in their agreement. For an accounting. And so appellants cannot reasonably claim that Herrick owed Cookies a duty to render such services at no profit to himself or his companies. Having found that the compensation he received from these agreements was fair and reasonable, we are convinced that Herrick furnished sufficient pertinent information to Cookie's board to enable it to make prudent decisions concerning the contracts. We concur in the court's assessment of the evidence presented and affirm the dismissal of the plaintiff's claims. I would so award attorney fees. All justices concur except Schultz, who dissents. I don't even really so much care about the dissenting opinion, but it's not that long, so we'll go through it. I believe that Herrick failed on this burden of proof by what he did not show. He did not produce evidence of the local going rate for distribution contracts or storage fees outside of the very limited amount of self-serving testimony. He simply did not show the fair market value of his services or expense for freight and storage costs. He did not show that his taco sauce royalty was fair. This was his burden. He can exceed on it by merely showing the success of the company. And the appellants have put forth convincing testimony that Herrick has been grossly overcompensated for his services based on their fair market value. Appellant's expert witness, a CPA, performed an analysis to show what the company would have earned if it had hired a $65,000 a year executive officer, paid a marketing supervisor, and an advertising agency a commission of 5% of each. So this is just some plaintiff expert with this 2020 vision. Paying an advertising agency commission of 5% of each sales built each built a new warehouse and hired a warehouseman. It was compared that with what the company actually did make under Herrick's management. The analysis basically shows what the operating costs of the company should be on the open market when hiring out the work to experts. In 1985 alone, the company's income would have doubled what it actually made. Were these changes made? The evidence clearly shows that the fair market value of the services is considerably less than what Herrick actually has been paid. Similarly, appellant's food broker expert witness testified that for $110,000, what the CPA analysis stated was the fair market value for the brokerage services. His company would have provided all of the services that Herrick had performed. The company actually paid $730,000 for those services, a difference of $620,000 in 1 year. In summary, I believe that majority was dazzled by the tales of Herrick's efforts and Cookie's success in these difficult economic times. In the process, however, it is forgotten that Herrick owes a fiduciary duty to the corporation to deal fairly and reasonably with it in his self-dealing transactions. Herrick is not entitled to skim off the majority of the profits through self-dealing transactions unless they're fair to the minority stockholders. At trial, he failed to prove how these charges were in line with what the company could have gotten on the open market. Because I cannot ignore this inequity to the company and shareholders, I must respectfully dissent. Okay, fine, that sounds good. So here's a note on the effect of approval of self-interested transactions by disinterested directors, and it goes on for about almost 3 pages before we reach the notes on shareholder ratification, which goes on for another 3 pages before we reach a new section of compensation. So 6 more pages probably won't kill us. Notes on the effect of approval of self-interested transactions by disinterested directors. The utility of further review. Even though a self-dealing transaction has been authorized by disinterested directors, there are reasons why the transaction should nevertheless be subject to some review for substantive fairness, although a more limited review than would be applied in the absence of such an authorization. First, by virtue of their personal relationships, directors are unlikely to treat each other with the degree of wariness they would apply to third parties. Second, a review of the substantive fairness of a fair dealing transaction may be thought of as surrogate for a review of the fairness of the process by which the transaction was approved. In a world of perfect information, a court would always determine by direct means whether directors who approved a self-interested transaction involving one or more of their colleagues were objective and impartial, and whether they approach the transaction with that degree of wariness with which they would approach transactions with third parties. In the real world, the courts may need to make these determinations by indirect means. If a self-dealing transaction has been approved by directors who are technically disinterested, is substantially unfair. It normally be inferred that either the approving directors were not objective and impartial, in fact, or that they were not as wary as they should have been because they were dealing with a colleague. Statutory judicial approaches. Most states have adopted statutes like those in California, Delaware, New York and the Model Act that address the effect of approval of self-dealing transactions by disinterested directors. An important question under these statutes is whether they preclude a judicial inquiry into the fairness of self-dealing transactions that have been so approved. Many of the statutes are susceptible to the interpretation that approval by disinterested directors precludes a judicial inquiry into fairness, but most or all of these statutes can also be interpreted not to preclude such an inquiry. The statutes fall into several categories in this regard. Some of the statutes, such as the California statute, expressly require some form of fairness test, even if a transaction has been approved by disinterested directors. Many of the statutes, such as the Delaware statute, explicitly require that approval by disinterested directors be in good faith, and such a requirement can be implied even where it is not explicit. It is often obscure whether good faith test is strictly subjective or has an objective content as well. For example, UCC 2-103 provides that in the case of a merchant, good faith is defined to include the observance of a reasonable commercial standards of fair dealing in the trade. Judge Friendly, when you look at Sam Wong and Son Inc. versus New York Mercantile Exchange, Judge Friendly held in 1984 that the rationality of a decision was relevant to determine whether a decision is made in good faith. By this, he added, we mean only a minimal requirement of some basis in reason, absent some basis in reason, action. Absent some basis in reason, action could hardly be in good faith, even apart from ulterior motive. Even courts that seem to use the term good faith in a relatively subjective way characteristically go on to review a decision to determine if it is irrational, egregious, or the like. This shows bad faith. Because of the uncertain meaning of good faith, see Section 2 infra, a good faith requirement opens the door to some judicial scrutiny of the fairness of self-dealing transactions that may have been approved by disinterested directors. Many of the remaining statutes can be interpreted to merely change the common law rule that self-dealing transactions are voidable without regard to fairness, rather than to preclude review for fairness. Thus, some courts have held that such a statute either renders a self-interested transaction not automatically voidable, that is, not voidable even if fair, or shifts the burden of proof. In addition to cookies, food products, see example, Holy Rest Inc. versus Trillar, Cohen versus Ayers, and Remillard Brick versus Remillard Dindini in California, Gaylord versus Natomas Company, California, again, 1989. And in Delaware, common law rule that self-dealing, what are we even talking about in all those cases is that the common rule of self-dealing transactions are voidable without regard to fairness rather than to preclude review for fairness, not automatically voidable even if not voidable even if fair, or shifts the burden of proof. Not voidable even if fair, or shifts the burden of proof. So for Delaware, in contrast, in Marciano, there's a couple things I'm looking at. I'm looking at, what is determinative? Is it bad faith? Is it self-dealing with or without regard to fairness? What is the answer to that question? Thus, some courts have held that such a statute either renders a self-interested transaction not automatically voidable, that is, not voidable even if fair, or just shifts the burden of proof. I guess didn't finish that sentence, but gave all these case titles, but the burden of proof then shifts with regard to the fairness analysis, which we just saw in cookies. So Delaware, in contrast, in Marciano versus No Cash, 1987, the Delaware Supreme Court stated that approval by fully informed disinterested directors under Delaware General Corporation Law, Section 144A1, or disinterested stockholders under similar next section, or next part of that section, permits invocation of the business judgment rule and limits judicial review to issues of gift or waste only with the burden of proof upon the party attacking the transaction. That's a big difference. Similarly, in Oberle versus Kirby in 1991, Delaware that is, the Delaware Supreme Court said, the key to upholding an interested transaction is the approval of some neutral decision-making body. A transaction will be sheltered from shareholder challenge if approved by a committee of independent directors or the shareholders. So this is more of like, I don't know if it's statutorily required, but it definitely is introducing an alternative. So the Model Act's regulatory approach is part 4, and then the ALI weighs in as part 5. So for the Model Act regulatory approach, by far the most detailed approach in self-dealing transactions is set forth in subchapter F of the Model Act. The draftsman of the Model Act made clear that when a self-dealing transaction that falls within its provisions is approved per the process set forth in the Act, that the transaction itself will not therefore be subject to further judicial review. So it's kind of like a safe harbor. And the self-dealing director will not be liable for damages because of such a conflict. That's great. I actually like this approach. The comment does observe that despite such approval, the transaction may be challenged, and the self-dealing director could be liable for damages on some basis other than the conflict. Section 8.60 broadly defines transactions that fall within the provision as both transactions in which the director is a party, as well as transactions in which the director has an indirect conflict of interest through the definition of a related person, i.e. the director or officer of an entity dealing with a corporation, notably more rigorous than the earlier generation of conflict of interest statutes. Okay. Such as the Delaware and New York statutes, the Model Act is very precise in setting forth the requirements that must be met for disinterested director and shareholder approval. See MBCA section 8.62 and 6.3, section 6.1, 8.61 clearly states compliance with either of these two sections insulates the transactions and the conflicted party to challenge because of the conflict. So the ALI weighs in section 5. It is widely believed that regardless of the form of the statute, at least outside Delaware, approval by disinterested directors will not prevent a court from reviewing self-interested transactions for obvious unfairness. Section 5.02 A2B of the ALI's Principles of Corporate Governance makes this implicit rule explicit by adopting a test intermediate between the business judgment rule and a full fairness test in cases where a self-interested transaction has been approved by disinterested directors. Under that section where there has been authorization by disinterested directors, the complainant must show that disinterested directors could not have reasonably believed the transaction to be fair to the corporation. This test is intended to be easier for the director or senior executive to satisfy than a full fairness test, although harder to satisfy than the business judgment standard. So that's where it is on the continuum for the intermediate test. The ALI is suggesting. Even in Delaware, it may be necessary to show that the directors who approved the transaction were not only disinterested but independent, and directors who passively approve a manifestly unfair transaction may be deemed to exhibit a lack of independence by virtue of that conduct. New York Stock Exchange Listed Company Manual, Section 312.03a. The notes on shareholder ratification are now coming up here. These are 4-part or more. An outside limit on the power of even disinterested directors or shareholders is the principle of waste. This principle is defined and explained as follows by Chancellor Allen in Lewis versus Vogelstein, Delaware Court of Chancery, 1999. A judicial standard for the determination of corporate waste is well developed. So this is case law on corporate waste. Roughly, a waste entails an exchange of corporate assets for consideration so disproportionately small as to lie beyond the range that at which any reasonable person might be willing to trade. Most often the claim is associated with a transfer of corporate assets that serves no corporate purpose, for which no consideration is at all is received. Such a transfer is an effective gift. If, however, there is any substantial consideration received by the corporation, and if there is a good faith judgment that in circumstances the transaction is worthwhile, there would be no finding of waste, even if the fact finder would conclude ex post that the transaction was unreasonably risky. Any other rule would deter corporate boards from the optimal rational acceptance of risk for reasons explained elsewhere. Courts are ill-fitted to attempt to weigh the adequacy of consideration under the waste standard or ex post to judge appropriate degrees of business risk. Chancellor Allen's definition was later quoted with approval by the Delaware Supreme Court in Brehm v. Eisner. The issue of waste, therefore, overlaps with the issue: what is the effect of shareholder ratification of a conflict of interest transaction? So this is bringing us into the scope of ratification. Differing views on effective ratification. Former Chancellor Allen in Lewis versus Vogelstein, 1997. So I guess this was earlier. Thoughtfully examined the possible effects of shareholder ratification of a self-dealing transaction. What is the effect under Delaware corporation law of shareholder ratification of an interested transaction? The answer to this apparently simple question appears less clear than one would hope or indeed expect. 4 possible effects of a shareholder ratification appear logically available. First, one might conclude that an effective shareholder ratification acts as a complete defense to any charge of a breach of duty. Second, one might conclude that ratification means that shareholders agree with the conduct. One might conclude that the effect of such ratification is to shift the substantive test on judicial review of the act from one of fairness that would otherwise obtain because the transaction is an interested one to one of waste. And third, one might conclude that a ratification shifts the burden of proof of unfairness to plaintiff, but leaves the shareholder protective test in place. And fourth, one might conclude perhaps just because of great respect for the collective action disabilities that attend shareholder action in public corporations, that shareholder ratification offers no assurance of assent of the character that deserves judicial recognition. Thus, under this approach, ratification on full information would be afforded no effect. Accepting the fourth of these facts, there are cases in the jurisdiction that reflect each of these approaches to the effect of shareholder voting to approve a transaction. And so, I I'm going to save my voice going into this, but I'm going to rewrite these parts of shareholder ratification into these 4. Again, ratification generally was 1. 2 was shareholder ratification. 3 was contemporary. Okay. This doesn't align. Okay. This is not a line. So let's rewrite it. 4 possible effects of shareholder ratification. So effect 1 is it's a complete defense. 2, it shifts the test from fairness to waste. And that would be like on judicial review. 3rd, so 4th would be nothing, no effect. 3rd has to do with the shift the burden of proof again. So we shift the test, but here we shift the burden of proof to plaintiff rather than defendant. That leaves the shareholder protective test in place. I don't really know what that test is. But anyway, since the rest of this is not just an elaboration on those 4, I guess I'm going to keep reading. Ratification generally. I start with principles broader than those of corporate law. Ratification is a concept of deriving from the law of agency, which articulates the ex post conferring upon or confirming the legal authority of an agent in circumstances in which the agent had no authority or arguably had no authority. Restatement 2nd of Agency, Section 82 from 1958. To be effective, of course, the agent must fully disclose all relevant circumstances with respect to the transaction to the principal prior to ratification. See example, Green Air Freight versus Air Cargo, Inc., 1972 in the Second Circuit, Restatement 2nd of Agency, Section 91, 1958. Beyond that, so they're analogizing, okay? Analogizing to agency law. And you've got Section 82, now Section 91. What was 82? To be effective, of course, the agent must fully disclose all relevant circumstances. This is transparency. 91, beyond that, since the relationship between the principal and agent is fiduciary in character, the agent in seeking ratification must act not only with candor, but with loyalty. Thus, an attempt to coerce the principal's consent improperly will invalidate the effectiveness of the ratification. And Restatement Section 100 probably goes on. Assuming that a ratification by an agent is validly obtained, what is the effect? One way of conceptualizing that effect is that it provides, provides after the fact, the grant of authority may that may have been wanting at the time of the Agents Act. Another might be to view the ratification as consent or as an estoppel by the principal to deny a lack of authority. And Agency Section 103, in either event, the effect of informed ratification is to validate or affirm the act of an agent as the act of a principal. Shareholder ratification. The differences between the shareholder ratification are all rules, and they're great. They're so on point. Of director action and classic ratification by a single principal lead to a difference in the effect of a valid ratification in the shareholder context. The principal novelty added to ratification law generally by the shareholder context is the idea, no doubt analogously present in other contexts in which common interests are held, that in addition to the claim that the ratification was defective because of incomplete information or coercion, shareholder ratification is subject to a claim by a member of the class that the ratification is ineffectual because the majority of those affirming a transaction had conflicting interest with respect to it, or two, because the transaction that is ratified constituted corporate waste. As to the second of these, it has long been held that shareholders may not ratify a waste except by a unanimous vote. From Sachs versus Brady, Delaware, 1962, the idea behind this rule is apparently that a transaction that satisfies the high standard of waste constitutes gift of corporate property, and no one should be forced against their will to make a gift of their property. In all events, informed, uncoerced, and disinterested shareholder ratification of a transaction in which corporate directors have a material conflict of interest has the effect of protecting the transaction from judicial review except on the basis of waste. The contemporary Delaware perspective, and the most significant consequence of the transaction constituting waste is that waste cannot be ratified by less than unanimous shareholder approval. Moreover, even this qualification still leaves open to what extent ratification should extend outside the realm of self-dealing transactions, that is, state conflict of interest statutes such as the New York Business Law Corp, Section 703, and Delaware General Corp, L, Section 144, clearly embrace shareholder approval as one of three mechanisms to address self-dealing transactions. The statutes leave open, however, the effect of such approval. And what about claims of self-interest such as illustrated in Gantler and shocking technologies that appear earlier in this chapter? Would ratification insulate the defendant's conduct in those cases? For the last 4 decades, despite Allen's erudite analysis, there has been a good deal of confusion in Delaware regarding the matter. Justice Travis Laster the effect on shareholder approval and enhanced scrutiny from 1914 is, a secondary source. The fog surrounding ratification appears to have lifted on this question in Corwin versus KKR Financial Holdings, Delaware 2015, dismissing a claim that directors breached their fiduciary duties diligently to take steps to seek the best offer when selling a company. When, there is no evidence of self-dealing. The longstanding policy of our law has been to avoid the uncertainties and costs of judicial second-guessing when the disinterested shareholders have had a free and informed chance to decide on the economic merits of a transaction for themselves. There are sound reasons for this policy. When the real parties in interest, the disinterested equity owners, can easily protect themselves at the ballot box by simply voting no. The utility of a litigation intrusive standard of review promises more cost to shareholders in the form of litigation rents and inhibition on risk-taking than it promises in terms of benefits to them. The reason for that is tied to the core rationale of the business judgment rule, which is that judges are poorly positioned to evaluate the wisdom of business decisions, and there is little utility to having them second-guess the determination of impartial decision-makers with more information in the case of directors or an actual economic stake in the outcome in the case of informed disinterested stockholders. In circumstances, therefore, where the stockholders have had the voluntary choice to accept or reject a transaction, the business judgment rule standard of review is presumably correct one and best facilitates the wealth creation through the corporate form. So this is a policy preference against judicial review of corporate self-dealing claims or transactions. Corwin itself is more fully examined in Chapter 14, treatment of the fiduciary obligations of directors when there is a change of control in the firm. The issue of bundling, so like that's the thing. This is a sale. In a sale, whereas here this is changing control of the firm. Example, sale. Example 2. This is 1. Issue of bundling. Corwin involved the firm selling itself to an unrelated firm. As will be seen in Chapter 15, such transactions require shareholder approval. Under Corwin's formulation, we can understand the shareholder vote as involving two distinct approvals combined into a single vote, approval of the transaction and excusing the directors of the failure to diligently shop for a better offer. While not a Hobson's choice, the choice is a distorted one. The shareholders may well wish both to take a deal that is on the table, especially if there is no other competing offer, other than not to undertake the sale that provides a modest premium over the status quo and pursue a claim against the directors for breaching their fiduciary obligations. However, Corwin holds that their approval of the deal forecloses their pursuing the directors. Either in the part of Gantler's decision that was not included in these materials, Gantler stated that ratification must be via a vote that is distinct from the one that is undertaken to comply with the statute. Okay, didn't know that. That's Gantler. Is this the rule? This stuff's important. I'm going to just write it as a rule, just like before I wrote something down. Shareholders may not ratify waste except by a unanimous vote. Who says? Shareholders must approve most mergers. Corwin rejected the position so that ratification can occur as a consequence of the shareholder approval that is mandated for such transactions by statute, provided there is full disclosure and the vote is not coerced, but is bundling of such a context inherently coercive. Except when. Except except when? Except mergers and acquisitions per Corwin. Reach of ratification statutes. Some acts are beyond ratification or even incapable of validation as a matter of equity. This occurs when the act or transaction is deemed void ab initio as a result of a failure to comply with the corporate statute of the Articles of Incorporation. See Star Surgical Co. versus Wagoneer, Delaware, 1991. In 2013, Delaware added 204 to the DGCO to provide a process by which corporations can validate such defective corporate acts. Once the steps set forth in Section 204 are completed, the earlier defective act is ratified, and the ratification relates back to the date the act was originally taken. Breathing life into what was to be legally dead can obviously have uncertain consequences. Thus, a companion provision, DGCL 205, confers jurisdiction to the Delaware Court of Chancery over the efficacy of an effects to be accorded the ratification. New Section 204 does not apply to acts discussed above that are voidable but not void, for which the doctrinal form of ratification is available. See also MBCA Section 146 to 1.52. So what do we call this? Defective corporate actions. We kind of talked about this in an earlier chapter. We'll say procedure 4. Now we finally reached compensation, and an hour into this recording. Argowal, executive compensation and corporate controversy. is some type of an article about it. And I'm just going to read the components. Much of the discussion in the academic literature is focused on the degree to which managers' interests are aligned with those shareholders. And you've got part 2, the structure of executive compensation, part 2.1, short-term components of compensation, part 2.2, long-term components of compensation, part 2.2a, restricted stock, B is stock options, and C is long-term incentive plans. And the increase in executive compensation has sparked a growing debate about whether such compensation is excessive, especially when average workers' incomes have been relatively stagnant. Furthermore, the high publicized bankruptcies and the collapse of in-share prices since 2000 have led some to argue that executive compensation practices, specifically the granting of stock options, are pernicious. Do executive compensation packages provide appropriate incentives to managers, thereby aligning their interests with those of shareholders, or do they actually destroy shareholder value over a medium to long run? Much of the, and then I just read much of the discussion is, on these temporal or on timing. So for the structure of executive compensation, in order to understand, this is part 2, in order to understand the determinants of incentives, we must first understand the components of executive compensation. Total annual compensation can be divided into 2 categories: short-term components of compensation and long-term. So in short-term components of compensation, for 2.1, include salary, bonus, and other annual compensation. Annual salary is fixed in advance and generally does not have an incentive component associated with it. The exception to this statement is that future increases in salary may in part be determined by current firm performance. Jansen and Murphy, 1990, show that the present value of the current and future increases in salary and bonuses are a small fraction of total incentives. Annual bonuses, I'm just going to scan. We're talking accounting terms here for performance through accounting calculations such as return on equity and assets and investment, EVA, economic value added, and a lot's being said there, like cost accounting type stuff for products and plans. And there are several points to note about short-term component compensation that have incentive features such as the bonus, not linked to stock performance, in the form of stock returns. Given that shareholders presumably care most about stock returns, this is somewhat surprising. It will become apparent, however, that long-term components of compensation are much more strongly linked to stock returns. For this reason, the right way to think about annual salary and bonuses is that any performance standard targets being met. Bonuses typically reflect how well a firm or executive has met non-stock return-based objectives established by the board. Other annual compensation is usually negligible. So long-term components of compensation, part 2.2, include new grants of restricted stock, new grants of stock options, long-term incentive plans, payouts, and other compensation. All other compensation typically includes gross ups for tax liabilities, prerequisites, and preferential discounts on stock purchases, contributions to benefit plans, and severance payments. Is usually relatively unimportant. And then you've got like kind of a breakdown of restricted stock options, and long-term incentive plans, which were all parts of the long-term components of compensation. But they weren't really greatly discussed in that paragraph I just read. So going into them more in depth, restricted stock grants are restricted in the sense that the executive must remain with the firm for a specified amount of time in order not to forfeit the stock grant. Restricted stock grants with a 5-year vesting period are typical. There are 2 practical implications of this restriction. First, the executive has potentially strong incentive to stay with the firm in order to benefit from the grant. Second, while the vesting period is in effect, the executive cannot sell the stock. She is in effect forced to have part of her compensation tied to firm performance over the vesting period. Vesting period. Restricted stock grants clearly align in executive interests with those of shareholders. So, for stock options, they become a primary mechanism through which managers' interests are aligned to those with shareholders. A stock option gives a manager the right, but not the obligation, to purchase a share of the firm's stock for a pre-specified price, known as the exercise price, on or before a pre-specified date. Most stock options are granted at the money, which means that the exercise price is set equal to the stock price on the day. The typical stock options grant has a life of 10 years. Stock prices on average increase from year to year. Over time, most stock options will move into the money, meaning that the current stock price is greater than the exercise price. Move into the money. That's how that is meant. Stock options usually have a vesting schedule. Well, what that means is that the current stock price is greater than the exercise price. Stock options usually have a vesting schedule associated with them, such as 10% of the option grant vests every 6 months. And for tax purposes, I focus on non-qualified options, which are the form of stock options that most executives receive. Non-qualified options have no tax implication at the time they are issued. When the option is exercised, the executive pays tax on the difference between the stock price and the exercise price at the ordinary income tax rate. The firm deducts the difference between the stock price and the exercise price as compensation expense. If the executive later sells the stock, then the executive pays tax difference between the sale price and the market price at exercise of the option at the capital gains tax rate, because the firm is able to deduct the difference between the stock price at exercise and the exercise price as compensation expense. Non-qualified options have favorable tax treatment from the firm's perspective. And favorable tax treatment is a significant part of the explanation for why the use of stock options has increased so dramatically. For long-term incentive plans payouts are similar to bonuses but are awarded for performance over several years. For example, a long-term incentive plan payout may be triggered if ROA is at least 15% for 3 consecutive years. In general, long-term incentive plans are not that important on a year-to-year basis because they occur only when a long-term target is met. I'm skipping note on tax treatment of executive compensation because I read it already. There's a bunch of authorities listed here, and then the first case on compensation is something that I'm going to get to in the next recording.